Welcome to the Deep Dive. Today, we're going to be looking at something pretty important for anyone in India who uses the internet, which is probably you if you're listening. We're talking about India's new data protection rules, specifically the Digital Personal Data Protection Rules 2025.
Yeah, these are a really big deal. And what's fascinating is how detailed they are.
We got the official document right here, so you can consider this your express lane to understanding what it all means.
Exactly. We're going to break down these rules, talk about the potential benefits, but also highlight some things that are, well, raising eyebrows.
Okay, so basically this is like the instruction manual for how your data can be handled online in India. It's all designed to put the Digital Personal Data Protection Act 2023 into action.
And it's worth noting that this is still just a draft. The Ministry of Electronics and Information Technology wants to hear from you. You actually have until February 18th, 2025 to give them your feedback. You can do that on the MyGov website.
So let's jump right in. One of the first things that caught my eye was this consent manager idea. Imagine a digital platform that helps you manage who can access your data and what they can use it for.
It's a cool idea, right? But it does make you wonder, will this actually make things easier for users, or will it just add another layer of complexity to everything? The rules do lay out some pretty specific requirements for these consent managers. Like, they have to have a really strong financial track record, and they have to prove that they can actually protect your data.
Yeah, they even give this example in the document about a person named X who uses a consent manager platform called P to interact with two banks. It shows how you might give consent to one bank directly, or even use your existing data with another bank to grant access to a third party.
It's definitely ambitious. The potential is there to really change how we share information online, but it'll be interesting to see how it actually works in practice.
For sure. Another big focus of these rules is on safeguarding your personal data. They get into the details here, talking about things like encryption, access control, and even data backups. It seems like they really want companies to be proactive about preventing data breaches.
And they should. Data breaches can be a nightmare. The document mandates encryption, secure storage, and strict access controls. It's all part of a multi-layered approach to security.
Speaking of breaches, there's a whole section on what companies have to do if your data health is compromised. They have to inform you in plain language, without delay, and be very specific about what happened.
Transparency is so important in those situations, and they only have 72 hours to report the breach to the Data Protection Board. That report has to include a ton of details, everything from what kind of breach it was to how they plan to fix it.
And here's where things get really interesting. The rules also address how long companies can hold on to your data. For certain businesses, e-commerce, online gaming, and social media, they have to delete your data after 3 years. That is, if you haven't interacted with them or used any of your data rights.
It's a bold move for sure. A lot of companies have been holding on to data indefinitely. But this raises the question, what about situations that go beyond those 3 years? What if someone needs their data for legal reasons later on?
That's a great point. It'll be interesting to see if they address that in the final version. Another area they focus on is children's data. Makes sense, right? They're requiring companies to get verifiable parental consent before processing any data from kids.
It's good to see them paying attention to children's online safety. They even include some detailed examples to show how this should work, which is helpful. It takes away some of the ambiguity and puts the focus on protecting those younger users.
Right, and finally, they outline the powers of the Data Protection Board. They'll be the ones investigating complaints and making sure everyone's following the rules.
Yeah, they have a big job ahead of them, investigating breaches, enforcing the rules, making sure companies are actually complying. They're like the watchdogs for our data in this whole new framework.
Definitely a lot of responsibility there.
For sure. Welcome back to our deep dive into India's draft data protection rules. We've only just scratched the surface here. There's still a lot more to uncover.
Right, we were just talking about how companies can't hold on to your data forever. But it turns out there are actually specific rules for when the original purpose for collecting your data is no longer valid.
Exactly. The draft rules outline what they call a deemed erasure provision. Basically, certain types of companies have to automatically delete your data after a specific period if you haven't interacted with them.
So let me get this straight. If I haven't logged into my account, or made a purchase, or even just visited a website, for a certain amount of time, they have to get rid of my data.
That's the idea. And for companies like e-commerce platforms, online gaming sites, and social media companies, the big players, that time limit is 3 years.
Wow, 3 years. But there must be some exceptions to this, right? What if a company needs to keep my data for legal reasons?
Oh, absolutely. There are definitely exceptions outlined in the document. They're not just going to randomly wipe your data. But the general principle is that they can't just keep it forever just in case. They have to have a valid reason.
Okay, that makes sense. And they can't just delete my data without any warning, can they?
Nope, not at all. They have to give you a heads up, at least 48 hours before deleting anything. And that notice has to be clear and easy to understand. It has to explain that your data will be deleted unless you take specific actions, like logging into your account.
So it's kind of like a use it or lose it policy for your data. I have to stay active to keep my data with that company.
You could think of it that way.
Yeah.
It definitely encourages companies to be more careful about how much data they collect and how long they keep it. It also gives you more control over your online presence.
I like that. So let's shift gears a bit and talk about government services. How do these rules change the way the government can use our data? I think that's something a lot of people are curious about.
You're right. It's a big question. There's a whole section in the draft rules specifically about how the state and its instrumentalities can use personal data when they're providing services. Things like subsidies, benefits, licenses, and permits. Think welfare programs, driver's licenses, or business permits.
So like the government could use my data to process my application for a driver's license.
Exactly. But there are safeguards in place. The rules lay out standards for processing this data to make sure it's done lawfully and responsibly. It can't just be a free-for-all.
Okay, that's good to hear. What kind of standards are we talking about here? What's in place to actually protect my data?
Well, for one thing, they have to make sure that processing your data is absolutely necessary for that specific purpose, like issuing that driver's license. They can't use it for anything unrelated to that specific task.
Right, and they have to make sure the data is accurate, right? They can't base decisions on outdated information.
Absolutely. They need to take steps to ensure the data they're using is current and correct.
And of course, they have to keep my data secure, just like any other company would, right?
Exactly. That's a fundamental requirement across the board. The rules really emphasize the importance of security safeguards, no matter who is handling the data.
I know some people might be concerned about the government having access to their data in the first place. Is there anything in the rules to address those concerns?
Well, transparency is a big focus. The government entity has to inform you that they're processing your data, and they have to give you contact information if you have questions or concerns. You have the right to know what's happening with your data.
So they can't just collect and use my data without me knowing about it?
Nope, not under these rules. They have to be completely upfront about what data they're collecting, why they need it, and how they're using it.
It sounds like they're trying to walk a fine line between using data efficiently to provide services and respecting people's privacy. It's a tough balance to strike.
You're right, it is. And these rules are an attempt to navigate that complex landscape.
We've talked about regular companies and the government, but are there any other groups that are treated differently under these rules?
Yes, there's a category called significant data fiduciaries.
Significant data fiduciaries. What does that even mean?
Well, these are companies or organizations that handle a large volume of personal data, or whose data processing activities could have a significant impact on users. Think big tech companies, major financial institutions, healthcare providers, those types of organizations.
So they get their own special set of rules.
You could say that. They definitely have additional responsibilities because of the scale and potential impact of their data operations.
Like what? What kind of extra responsibilities do they have?
Well, for one, they need to conduct regular data protection impact assessments and audits. It's about proactively looking for potential risks to users' data and taking steps to address them before they become problems.
So they can't just react to problems as they arise. They have to try to anticipate them.
Exactly. They also need to carefully assess any algorithms they use to make sure they aren't creating risks to users' rights. And in some cases, they might be restricted from transferring personal data outside of India.
It sounds like the rules are trying to create extra layers of protection around these companies, recognizing that they hold a lot of power when it comes to data.
That's a good way to put it. It's acknowledging that their scale and the type of data they handle require a higher level of scrutiny.
Makes sense. And that brings us to the question of data transfers. These rules must address whether companies can just send our data anywhere in the world.
Absolutely. That's a key issue, and one that's been the subject of a lot of debate.
So what's the verdict? What do the rules say about sending data outside of India?
Well, they generally allow it to transfer personal data outside of India. But, and this is important, there are exceptions.
Okay, what kind of exceptions? Under what circumstances would they restrict data transfers?
The government can restrict data transfers to specific countries or regions if they have concerns about the adequacy of data protection laws in those places. It's about making sure your data is protected, even if it's being sent to another country.
It's good to know they're thinking about those cross-border implications.
Yeah, it's becoming increasingly important in our globalized digital world.
Now remember, all of this is still just a draft. People can still weigh in with their feedback and suggestions.
That's right. The public consultation window is open until February 18th, 2025.
So if you have any thoughts or concerns about these rules, now is the time to speak up. Your input can actually help shape the final version of these rules, which will have a real impact on your digital life.
Absolutely. It's a reminder that in the digital age, staying informed and engaged is more important than ever. Your data is valuable, and it's essential to understand how it's being used and protected.
And we're back for the final part of our deep dive into India's draft data protection rules. We've covered a ton of ground already, but like with any new regulations, there are always going to be questions and concerns about how it will all actually work.
For sure. Especially since these are still just draft rules, you still have time to make your voice heard. The deadline for feedback is February 18th, 2025.
So let's jump into some of the things that have people talking. One thing that stood out to me was this idea of deemed consent in certain situations.
Yeah, that's been a big talking point. There are times when the rules say that consent can be deemed to have been given, even if you haven't explicitly agreed to let them use your data.
So like if I'm using a service to prevent fraud
Hmm.
or to make sure a network is secure,
Mhm.
they can just assume I'm okay with them using my data.
Well, the rules do try to be specific about when this applies. It's usually for things that are considered essential for a service to function, but it does raise questions about how much control you really have.
Right, seems like there's some gray area there. And speaking of gray areas, what happens when these rules might overlap with other laws or even conflict with them?
That's a good question, and it's something that definitely needs to be addressed. It's important to have a clear hierarchy of laws and to make sure that these new rules don't weaken other legal protections that are already in place.
Definitely. Another issue that's come up is the potential for these rules to be used for surveillance or censorship. Some people are worried that the government could use these rules to access people's data for reasons that go beyond what's allowed.
Those concerns are understandable for sure. Data privacy is a big deal. Transparency and accountability are going to be crucial here. The government needs to be open about how these powers are being used, and there need to be strong oversight mechanisms to prevent abuse.
It all comes down to trust, right?
Hmm.
Having the rules is one thing, but making sure they're enforced fairly and consistently is another.
Exactly. Enforcement is key. If companies or the government can break these rules without any consequences, the whole system falls apart.
Right, and then there's the practical side of things, actually implementing these rules. These rules are complicated. It's going to take time and resources for companies to adapt.
That's true. There will definitely be costs involved, and it's important to think about how those costs might impact users or even affect innovation in the tech sector.
It's a balancing act, for sure. So it seems like these draft rules are a step in the right direction, but there's still work to be done.
I think that's a fair assessment. There's a lot to be optimistic about, but there are also areas that need more clarification, and that's where you come in. This is your chance to give your feedback.
Exactly. This is your opportunity to help shape the future of data protection in India. Read the draft rules. Think about how they might affect you, and share your thoughts on the MyGov website.
It's a reminder that we all have a responsibility to protect our digital rights. Stay informed, ask questions, and make your voice heard.
Well, that brings us to the end of our deep dive. I hope this has given you a better understanding of what's going on and how you can get involved.
It's an important conversation. Stay curious, stay informed, and keep advocating for your digital privacy.